Hi, and thank you for joining me. Today I'm going to talk about the rules of intestacy, what it is, how it applies, and how it can affect you. The rules of intestacy are a set of rules set down by the government in law as to what happens when somebody dies without a will. It's a common myth that the government takes everything if you die without a will, which is not the case in 99% of the times. There is a predefined set of rules as to who gets what when you die and if you die without a will. Today, I'm going to talk about the first scenario, which is if you are married and you die without a will. Firstly, if you're married and you have children, then the law, the rules of intestacy, will set down that the first £270,000, together with the personal possessions, all pass to the surviving spouse. If there is anything in excess of the £270,000, then that is then split a further two ways. Half of that then passing to the spouse, and the other half then divided equally between the children. So if you have less than £270,000, then in effect the spouse receives everything and your children get nothing. What are the things you need to consider in these scenarios? Well, firstly, if your children are children from a previous relationship, whether you were married or not, then there's a chance they might not benefit, because if you are married and you have less than £270,000, well, the spouse receives all of it, and therefore your children will not receive anything from your death. They may or may not from your spouse's death, but that's up to that person to benefit your children, which may cause a problem if those children are not the spouse's children. If they are and they're joint children, then obviously that may not be an issue, but it is something worth bearing in mind. If there are assets in excess of £270,000, then the children will benefit and receive some of that. However, the things to bear in mind there are how that £270,000 and the excess is made up. If it's all tied up in a property, let's say you have a house worth £500,000, £750,000, for example, then it's going to be a difficult exercise to carve up that £270,000 for the spouse and then the rest for the children. It gets a little bit complicated because all of that's tied up in the bricks and mortar, which may cause acrimony, especially again if the children are from a previous relationship, because they may want their share of the property, but your spouse is living there. It can get awkward. The other thing to bear in mind is the children will benefit at the age 18. Because you've not written a will, this is the rule set down by law, 18 is the limit. So once they hit 18, then they are entitled to their share. So this may be too young. You may think they're not mature enough to receive, whether it's cash or a share of the property, for example. And therefore, if you do want to have that control, writing a will is the best way, because you can stipulate an age limit, for example, 18, 21, 25, or a mixture. One other thing to bear in mind is if you died without a will and assets pass to the spouse, whether it's all, if your assets are less than £270,000 or a share, then what happens when that spouse meets somebody new? Whether she makes a will or again does not make a will and the rules of intestacy apply. Well, again, the £270,000 or a share of that will pass to the new surviving spouse. So again, there's a risk that your children, whether children from your previous relationship or children from your current relationship, may end up losing out. So it's very important that you either consider the implications of relying on the rules of intestacy, which should only ever be relied on as a default, or you prepare a will to make sure that your wishes are carried out so that your family benefit the way you want them to. Next time, I'm going to talk about what happens if you are married but you have no children. Thank you.